Ever get the feeling that the legal system is just, I don't know, like a tangled web of jargon and loopholes?
Right.
Well, today we're unraveling one of the most fascinating strands, torts.
Ooh, torts.
Think of it as like the Wild West of civil law, where everyday wrongs collide with the fight for justice.
And trust me, you don't need a law degree to appreciate this stuff. Understanding the basics of torts can arm you with the knowledge you need to navigate tricky situations
Right.
and maybe even level the playing field a little bit.
Okay, so let's unpack this. For starters, what is a tort?
Okay.
I'm picturing pies, but something tells me we're talking about something a bit more serious.
Definitely not about dessert.
Okay.
Though some legal battles can be pretty rich, let's just say that.
Okay.
In simple terms, a tort is a civil wrong that causes harm to another person. Think of it like this. We all have these invisible strings connecting us,
Okay.
those duties we owe to each other to act with reasonable care. And each action we take can tug on those strings. And if someone's actions are careless and they cause harm, well, that's where tort law steps in.
So it's not about the police hauling you away in handcuffs,
Mm-hmm.
but more about, like, one person holding another accountable for causing harm,
Yes.
often with, like, a hefty price tag attached.
Often, very much so. Yep.
Okay.
And the most common type of tort we encounter, probably without even realizing it, is negligence.
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 Sounds like something my old college roommate was guilty of when it came to doing the dishes.
Right.
But we're talking about real-life consequences here, not just a messy sink.
Exactly. In a legal context, negligence means that someone acted carelessly, or in some cases, failed to act, and that carelessness led to someone else getting hurt.
Okay, so let's say I'm walking down the street, not paying attention. I trip over a carelessly placed scooter, and I break my wrist.
Okay.
Whose fault is it?
Ooh.
Am I to blame for my absent-mindedness? Or is the scooter owner in hot water for, like, leaving a tripping hazard on the sidewalk?
That's where things get really interesting, and why understanding these concepts is so important. In your scooter scenario, the law looks at a few key things. First, did the scooter owner have a duty to prevent that kind of harm?
So, like, a responsibility to not turn the sidewalk into an obstacle course?
Precisely. Everyone has a general duty to act with reasonable care so we don't create unnecessary dangers for others. But the level of duty can change depending on the situation.
Okay. So the scooter owner probably shouldn't have just left it sprawled out in the middle of the sidewalk.
Right.
But what about my role in all of this?
Well, that brings us to the second element of negligence, breach of duty. Did the scooter owner fail to meet their responsibility to keep the sidewalk safe?
It seems pretty clear-cut in that case, right?
Right.
A reasonable person probably wouldn't just abandon their scooter in the middle of the sidewalk.
Right. Now, let's say the scooter was tucked off to the side, but you were rushing to make a train and weren't watching where you were going. That's where something called comparative fault might come into play. Comparative fault. So, like figuring out who messed up the most.
Essentially, yes.
Hmm.
It means that multiple parties could share the responsibility for damages based on their percentage of fault.
Okay.
So even if the scooter owner was partially to blame for leaving it in a less than ideal spot, you might also bear some responsibility for not paying attention.
Okay.
The court would consider all the factors and decide what's fair.
Okay, so let's say the court decides it's 50-50. We were both a bit careless.
Right.
Does that mean I can only recover half of my medical bills for my broken wrist?
Exactly.
Wow.
In many states, if you're found partially at fault for an injury, the amount of damages you can recover is reduced accordingly. It's
Yeah.
all about finding a balance.
Interesting. So we've covered duty and breach of duty. But what about the actual harm? I mean, what if I tripped over the scooter but I walked away unscathed?
That brings us to the third element,
Mm-hmm.
injury. For negligence to be actionable, there has to be some actual harm or damage.
Okay.
This could be the physical injury, property damage, financial losses.
Or even emotional distress in certain cases.
So no broken bones, no case.
Not necessarily. Even if you didn't break your wrist, you might have still suffered some harm. Did you twist your ankle?
Right.
Suffer a concussion? Those count too.
Right.
The type and extent of the injury play a big role in determining the amount of damages you might recover.
Got it. Harm can come in many forms.
Yeah.
Okay, last but not least, we need to connect the dots between the careless action and the harm that it caused. It's like that game mousetrap, but with more legal paperwork.
You're talking about causation, the final element of negligence.
Yes.
And you're right, sometimes it's a complex chain reaction. We need to establish that the breach of duty directly led to the injury. Let's imagine a different scenario this time, a slippery floor.
Okay.
Okay.
Set the scene for me.
Picture this. You walk into a grocery store, and there's a puddle of spilled juice on the floor. No wet floor sign, no one cleaning it up.
Uh-oh.
You slip, you fall, and you dislocate your shoulder.
Ouch. That definitely sounds like the grocery store might have some explaining to do.
Right. In this case, the store had a duty to maintain a safe environment for customers. They breached that duty by failing to clean up the spill or put up a warning sign.
Right.
Your dislocated shoulder is the injury.
Yes.
And it seems pretty clear that had the spill been addressed, you wouldn't be nursing a sore shoulder.
Right. So that's causation in a nutshell. The spill caused the fall, which caused the injury. But are there ever situations where it's not so clear-cut? Like, what if I tripped over my own shoelaces while simultaneously slipping on a strategically placed banana peel?
Okay.
Who's to blame then?
Now you're getting into the fascinating and sometimes frustrating realm of proximate cause. It's all about foreseeability. Could a reasonable person have predicted that their actions would lead to the harm that occurred?
So if I'm understanding this correctly, even if there's a technical link between someone's actions and my injury, they might not be fully liable if the injury was, like, totally out of left field, something no one could have seen coming.
Exactly. It's not enough to say, well, technically, if I hadn't eaten X, then Y wouldn't have happened. The connection has to be closer than that. The harm needs to be a reasonably foreseeable consequence of the action.
Okay, so it's not just about cause and effect. It's about cause and foreseeable effect.
Yes.
And that, my friend, is why we have lawyers who specialize in this stuff. But let's say, hypothetically speaking, that I'm a very clumsy person.
Okay.
In fact, I'm known for my, like, spectacular spills.
Uh-oh.
Does my inherent clumsiness get the grocery store off the hook for the juice debacle?
That's where another intriguing legal principle comes into play. The eggshell skull rule. And no, it's not about actual eggshells.
Okay, you've got my attention. Tell me more about this eggshell skull business.
Yeah.
Does it have something to do with being extra fragile? Because I do pride myself on being rather delicate.
In a way, yes. The eggshell skull rule basically says that you take your victim as you find them. It means that even if someone has a pre-existing condition that makes them more susceptible to injury, the person who caused the harm is still liable for the full extent of the damages.
So even if a slip on a banana peel might have only given a normal person a bruised ego, if I, the clumsy queen, were to suffer a concussion, the grocery store is still on the hook.
You got it. You can't argue your way out of responsibility by saying, well, they were just extra fragile. It's about taking responsibility for the consequences of your actions,
Right.
even if those consequences are magnified by someone's pre-existing vulnerabilities.
This is getting juicy.
Yeah.
So we've covered carelessness, but what about those situations where someone means to cause harm? That's a whole different ballgame, right?
Absolutely. We're moving out of negligence territory and into the realm of intentional torts.
Okay, buckle up, everyone, because things are about to get real. Intentional torts, it sounds like something straight out of, I don't know, a courtroom drama.
Right.
But the reality is these situations probably pop up more often than we think, right?
That's right. And while we hope you never find yourself on either side of these cases, understanding the basics can be, like, really eye-opening.
Okay.
It's about recognizing that sometimes harm isn't accidental, it's deliberate.
And when we're talking about intentional torts, we're dealing with a whole different level of legal responsibility.
Yes,
right?
yes.
I mean, a spilled latte is one thing, but
Yep.
a carefully planned scheme to ruin someone's reputation, that's a whole different level of messed up.
You hit the nail on the head. With intentional torts, intent is key.
Okay.
It's the difference between carelessly bumping into someone on a crowded street and, like, shoving them on purpose. The law recognizes that distinction, and it takes it very seriously.
Okay, so let's dive into some real-world examples. I think everyone has a story about a neighbor's barking dog or a roommate who borrowed their favorite sweater and never returned it. Those fall under the umbrella of intentional torts. Right.
They certainly could. Let's start with those noisy neighbors.
All right.
If they're consistently blasting music at all hours of the night, preventing you from sleeping, or letting their dog bark incessantly, you might have a case for nuisance, a type of tort that covers unreasonable interference with your use and enjoyment of your property.
So it's not just about, like, physical intrusions onto your property, but also about things like noise or smells, even vibrations that disrupt your right to peace and quiet. I'm picturing a wind chime convention happening next door.
You've got the right idea. The key is that the interference has to be unreasonable. A little bit of noise from time to time is one thing, but constant disturbances that go beyond what a reasonable person should have to tolerate that could be considered a nuisance.
Okay, that makes sense. So, what can you actually do about a nuisance? I'm guessing a strongly worded letter rarely does the trick.
It really, unfortunately, often doesn't. In those cases, you might need to take legal action to get the other party to stop the disruptive behavior.
Okay.
This could involve seeking something called an injunction, which is a court order requiring someone to stop doing something.
So it's like a legal cease and desist order.
Exactly. Now, let's move on to that borrowed sweater scenario. If your roommate swiped your favorite cashmere and decided to keep it, or even worse, sell it for a profit, we're talking about conversion, the civil equivalent of theft.
Cashmere crimes, I knew it.
Yeah.
But seriously, how does conversion actually work? It's just stuff, right? Why does the law care so much?
Because your stuff matters.
Okay.
And the law recognizes that you have a right to your property.
Right.
Conversion is about someone intentionally taking control of your property without your consent, essentially depriving you of its use and enjoyment.
So it's not just about, like, damaging someone's property. It's about essentially stealing it and preventing the rightful owner from using it.
Yeah.
It's like that saying, possession is 9/10 of the law.
Exactly. Now, let's say you politely ask for your sweater back, and your roommate responds by, let's say, locking you in your room. That's a whole other level of intentional tort. We're talking false imprisonment.
Whoa, things just escalated quickly. So it's not just about being, like, locked up in a physical sense, right?
Right.
It's about being unlawfully restrained or confined, even if it's a little more subtle.
You got it. False imprisonment occurs when someone restricts another person's freedom of movement without their consent and without legal justification.
So if someone uses, like, threats or intimidation to prevent me from leaving a room, even if there's no actual lock on the door, that could still be considered false imprisonment.
Absolutely. It's about creating a situation where a reasonable person would feel trapped and unable to leave, even if it's more psychological than physical.
This is giving me claustrophobia just thinking about it.
Right.
Okay, so we've covered property, freedom of movement, but what about protecting ourselves from those who mean to do us physical harm?
That's where we get into the realm of assault and battery, two of the most, I'd say, well-known intentional torts.
Yeah.
And while they're often lumped together, there's a really crucial legal distinction between the two.
Okay, break it down for me. What's the difference between those two fighting words?
Assault is all about creating fear. It's the threat of immediate harm. Battery, on the other hand, is the actual physical contact. It's the difference between someone swinging a fist at you and the punch actually landing.
So if someone shakes their fist at me and yells, "I'm gonna get you," that's assault.
It could be, especially if a reasonable person in your shoes would genuinely fear that they were about to be harmed.
Okay.
It's about that immediate sense of danger, that feeling of, oh no, something bad is about to happen.
And if they follow through with that threat and actually hit me, that's battery.
Exactly. Battery is about the unlawful and intentional touching of another person without their consent. It doesn't have to result in like a black eye or a broken bone. Even a light shove can be considered battery if it's done without justification.
So basically, keep your hands to yourself unless you have a really, really good reason not to. Now, what about those situations where someone hurts you without actually laying a finger on you? I'm talking about emotional distress, the kind of harm that leaves, like, invisible scars.
That's where things get really interesting and legally complex.
Okay.
We're talking about intentional infliction of emotional distress.
Okay.
Okay, IID for short. It's a mouthful, I know, but it covers those situations where someone's outrageous conduct intentionally or recklessly causes severe emotional harm to another person.
Okay, so we're not talking about your average bad day or a rude comment from a stranger on the internet. This has to be, like, next level emotional damage.
Absolutely. For conduct to qualify as IID, it has to be truly outrageous, beyond the bounds of what a civilized society would tolerate. Think extreme and outrageous behavior that would shock the conscience of a reasonable person.
So what kind of situations would fall under this umbrella? Give me some examples.
Imagine a scenario where someone spreads vicious lies about you, leading to public humiliation and severe emotional distress.
Okay.
Or a case where someone repeatedly harasses or stalks you, making you fear for your safety and well-being. These are actions that go beyond mere insults or disagreements. They're calculated to cause serious emotional harm.
Those are some heavy examples, but proving emotional distress seems a lot trickier than, say, like, documenting a broken leg. It's not like you could just point to an x-ray and say, see, there's the emotional damage.
You're right, it can be very challenging. Courts often look for evidence of severe emotional suffering. such as needing therapy or medication, experiencing sleep disturbances, or exhibiting physical symptoms like anxiety or panic attacks. It's about showing that the emotional distress was real, debilitating, and directly caused by the defendant's outrageous conduct.
Wow, this is a lot to process.
Yeah.
Okay, so we've covered a lot of ground in the world of intentional torts,
We have.
from nuisance and conversion to assault, battery, and even emotional distress.
Right.
It's a lot to wrap your head around, but it seems like the key takeaway here is that intent matters a lot.
Absolutely. When it comes to intentional torts, the law sends a clear message. You are responsible for the consequences of your actions,
Right.
especially when those actions are deliberate and intended to cause harm.
So choose your actions wisely, everyone, and maybe think twice before borrowing that cashmere sweater without asking. But let's shift gears for a moment and talk about a concept that always kind of makes me scratch my head a little bit. Strict liability.
Okay.
This is where it gets tricky, right?
Yes.
Because now we're talking about situations where someone can be held responsible for harm even if they weren't necessarily negligent or intentionally causing trouble.
You've got it. Strict liability is a fascinating and sometimes controversial area of tort law.
Oh.
It's about holding someone liable for harm caused by their actions, even if they took all the reasonable precautions in the world to prevent it.
So it's like saying, hey, you were doing something inherently risky, and even though you tried to be careful, stuff happens, and now you're on the hook.
That's a great way to put it. There are a couple of main areas where strict liability tends to pop up: abnormally dangerous activities and product liability.
Give me some, like, real-life examples of these so-called abnormally dangerous activities. Is this where my fear of clowns comes into play?
Well, clowns can be scary, but they're not usually considered abnormally dangerous in a legal sense unless they're juggling chainsaws or something.
Yeah.
Think about things like blasting dynamite, storing explosives, or even keeping wild animals as pets. These are activities that carry an inherent risk of harm no matter how careful you are.
Okay. So if my neighbor decides to take up dynamite fishing in their backyard pool, and I'm picturing a very small pool, they're probably going to be held liable if someone gets hurt, even if they were, like following all the dynamite fishing safety regulations to a T.
You're catching on quickly. It's about recognizing that some activities are inherently risky, and those who choose to engage in them are assuming a certain level of responsibility for any harm that might occur,
Okay.
regardless of their intentions or precautions.
So even if you do everything by the book, you're still on the hook if things go sideways. What about product liability? That one hits close to home for anyone who's ever bought a kitchen gadget that turned out to be more dangerous than useful.
Product liability is a big deal. It's all about holding manufacturers, distributors, and sellers responsible for defective products that cause injuries.
Okay, so let's say I buy, like, a brand new blender, top of the line, all the bells and whistles. I'm making my morning smoothie, and the thing explodes, sending shards of glass and kale flying everywhere.
Oh, no.
Traumatic, yes.
Mhm.
But is it product liability?
It could be. With product liability, it's not about proving that the manufacturer was careless or intended to harm you.
Right.
It's about the product itself being defective and that defect causing the harm.
So even if the blender company was, like, super careful in their manufacturing process, if my smoothie explosion was the result of a faulty blade or some design flaw, they could still be held responsible under product liability.
You bet.
Wow.
It's about putting the burden on companies to make things safe, not on consumers to, like, dodge defective products. Of course, there are different types of defects that can trigger product liability.
Okay.
There could be a manufacturing defect, meaning that one specific blender was put together wrong, even if the design is fine.
So like a rogue blender on the assembly line.
Exactly. Or there could be a design defect, meaning that every blender made from that design is flawed and potentially dangerous.
Okay, so if every blender in that model has a tendency to self-destruct during a kale smoothie session, that's a design flaw, and the company messed up big time.
You got it. And in either case,
Right.
the manufacturer, distributor, or seller could be held liable for the blender's explosive outburst.
This is making me rethink my morning smoothie routine. But seriously, strict liability is really fascinating because it seems to kind of, like, turn the tables a bit.
It does.
Instead of having to prove negligence or intent, the focus is on the product or activity itself and the inherent risks involved.
Exactly. And it's all about protecting consumers and the public from harm, even in situations where it's really difficult to pinpoint specific acts of negligence.
So it's like saying, look, some things are just inherently risky. And if you choose to sell those things or engage in those activities, You're accepting a certain level of responsibility for whatever might happen.
Yeah.
It's a brave new world out there, and knowing your rights is more important than ever.
I couldn't agree more.
This has been a whirlwind tour of the wild world of torts. From careless spills to exploding blenders, it seems like there's no shortage of ways we can bump into legal trouble
That's right.
or find ourselves seeking justice in our daily lives.
That's the thing about tort law. It's everywhere. It's the legal backdrop to so many everyday interactions, and understanding the basics can really empower you to navigate those interactions with a little more confidence and a lot more awareness.
Well said. But before we wrap things up, I think we need to revisit the concept of defenses, because even if someone can, clearly demonstrate that a tort has occurred, it doesn't automatically mean that they're headed for a big legal victory, right?
Right.
Sometimes there's more to the story.
You're absolutely right. Even if someone presents a seemingly airtight case, the defendant might have some legal tricks up their sleeve. We're talking about affirmative defenses, ways for the defendant to push back and argue that they shouldn't be held fully liable or maybe even liable at all.
Affirmative defenses, it sounds like they're going on the offensive even though they're the ones being accused.
In a way, they are. They're putting forward their own arguments to try and reduce or eliminate their responsibility for the harm that occurred.
Okay, so give me the rundown of these legal maneuvers. What are some common affirmative defenses that defendants might use in tort cases? Okay, so spill the tea on these affirmative defenses. What are some of the go-to strategies that defendants might use to build their case?
Well, one common defense we often see is contributory negligence.
Okay.
It's a bit stricter than comparative fault, which we talked about earlier.
Right.
And it can sometimes completely prevent the plaintiff from recovering any damages.
Wait, so even if someone is found liable for a tort, they might not have to pay up if the other party was also being, a bit clueless. That doesn't seem fair.
It might seem counterintuitive, but the law recognizes that sometimes everyone involved in a mishap shares some of the blame. Contributory negligence applies in those situations where the plaintiff's own carelessness contributed to their injuries.
So give me an example of how this plays out in, the real world.
Let's say you're jaywalking across a busy street. Not the smartest move, right?
Hey.
And a car is speeding down the road, doesn't manage to stop in time, and you get hit. Now, the driver was clearly in the wrong for speeding, but you also weren't exactly playing it safe by, darting into traffic.
Okay, so it's like that saying, it takes two to tango. But instead we're talking about, a legal tango with some potentially high stakes.
Exactly. In this scenario, the driver's lawyer could argue that your decision to jaywalk contributed to the accident and that you share some of the blame for your injuries.
Okay.
And in some jurisdictions, even a small amount of negligence on your part could prevent you from recovering any damages at all.
Wow. Talk about adding insult to injury. But hold on, what if you were jaywalking, but the driver was being, super reckless and could have avoided hitting you if they had just been paying attention? Does that change things?
You're thinking like a lawyer. That's where a fascinating exception to contributory negligence comes into play. The last clear chance doctrine.
Last clear chance. It sounds like a plot twist in a legal thriller.
It kind of is. This doctrine recognizes that even if the plaintiff was partially at fault, if the defendant had the very last opportunity to avoid the accident and failed to do so, they can still be held liable.
Okay, so in our jaywalking example, if the speeding driver had, ample time to see you and slam on the brakes, but was too busy texting to react, you might still be able to recover damages because they had the last clear chance to prevent the accident.
Exactly. It's about pinpointing who had the final opportunity to prevent the harm, even if both parties were initially acting carelessly.
This is getting really nuanced. It seems like there's always another layer to uncover when it comes to tort law. Are there any other big picture defenses that we need to know about?
Well, there's assumption of risk, which we touched on a bit earlier.
Right.
It's the classic, you knew what you were getting into, defense.
Right. So if I decide to go bungee jumping, there's an inherent risk involved, and the bungee jumping company isn't necessarily liable if I happen to have a less than graceful landing.
Exactly. When you knowingly and voluntarily engage in activities that carry inherent risks, like extreme sports, for example, you're generally assuming those risks as part of the experience.
So choose your thrills wisely, everyone. But what about situations where you're, like, trying to sue the government? I've heard that comes with a whole other set of hurdles.
You're right about that. Suing the government isn't as straightforward as suing, let's say, an individual or a company. The government enjoys something called sovereign immunity.
Sovereign immunity. It sounds intimidating, like something out of Game of Thrones. Does that mean the government is, like, above the law?
Not exactly above the law, but it does make things a bit more complicated.
Okay.
Sovereign immunity essentially means that the government can't be sued without its consent.
So it's like a legal shield that protects the government from being bombarded with lawsuits.
In a way, yes. It's rooted in the idea that the government needs a certain level of protection to function effectively without being, bogged down by frivolous lawsuits. But it's not an impenetrable shield. There are exceptions.
So it's not impossible to sue the government, but it's definitely an uphill battle.
Precisely. There are specific procedures and requirements that need to be followed, and it's always wise to consult with an attorney who specializes in this area of law if you're considering suing a government entity.
Good to know. Well, this has been quite the deep dive into the wild world of torts. From careless spills to exploding blenders, it seems like there's no shortage of ways we can bump into legal trouble.
That's right.
Or find ourselves seeking justice in our daily lives. So, as we wrap up this episode, I want to get your final thoughts on, well, I guess, on everything we've talked about. What are some of the key takeaways that you hope our listeners walk away with today?
That's a great question. I think the most important thing to remember is that tort law is like all around us.
Right.
It's not just something that exists in courtrooms or textbooks. These principles come into play every day in our interactions with others.
Right.
Whether we're driving a car, walking down the street, or even just interacting with our neighbors, understanding the basics of tort law can really empower us to navigate those situations with, a bit more awareness and maybe even a little more confidence in our rights and responsibilities.
Like, I love that. So basically, a little legal knowledge can go a long way in helping us avoid those oops moments that could land us in hot water or worse. It's about being informed, being aware of the potential consequences of our actions, and, maybe thinking twice before we jaywalk across a busy street or borrow that cashmere sweater without asking.
Exactly. It's about being mindful of those invisible strings that connect us all. Those duties we owe to each other to act with reasonable care and, to avoid causing harm whenever possible.
Beautifully said. This has been The Deep Dive, your shortcut to legal lingo and the fascinating world of torts.
Until next time.
Until next time, stay safe, stay informed, and remember, a little legal knowledge can go a long way.